It's wonderful to greet you again. The large number of people here, even at 8:35 a.m. on a Saturday morning, I think is a tribute to the quality of the speakers and the high expectations for this morning. Our first panel is about guns, and I'm going to turn it over to Bert Newborn, our moderator, whom I think is not carrying this morning.
My license was denied. Welcome. We've got a wonderful panel on tap for you with some terrific speakers and a lot to live up to, because the two panels yesterday I thought were extraordinary, and so the conference is off to a great start. As Michael points out, this is a panel that focuses on the Second Amendment, on Bruen, and the questions that the panelists, I think, will ask each other and ask the floor for comment on is whether the new technique or the insistence in Bruen that history can be a determinate way of deciding these cases, and moving to a vision of history in which you look at the regulatory structure that was put into place roughly contemporaneously with the ambiguous text. And so since we've got such an array of talent on this panel, and there are 5 people, I'm not going to introduce, and I'm not going to take time. The introductions are all in your packets, and you'll be as amazed as I was about the wonderful writings that we have. What I am going to do is something radical, though. I'm going to reverse the order, because Adam Winkler gets tired of going last all the time. So we'll start with Adam, and we'll move this way. So Adam, you're up.
Okay. Well, thank you very much. Unexpected. I was just getting ready to settle in for a few minutes. So first of all, it's a thank you for all coming, and special thanks, of course, to Mike McConnell for organizing this conference. Yesterday's panels on tradition and liquidation I thought were really fascinating, detailing the ways in which we, the people, shape constitutional meaning outside of the formal amendment process and outside of the courts. Mike, I never thought you would be the one to organize the best conference I've ever been to on living constitutionalism. In my brief time, I'd like to make 4 points. First, although the text history and tradition methodology appears to be ascendant, it does not explain key features of the Bruen decision. Second, that one prominent way that Bruen purports to use history, by reasoning that a scope of a right is determined by the absence of government regulation, is fundamentally misguided. Third point, that text history and tradition is justified as being less subjective, more predictable, and more manageable than interest balancing, but that the early returns on text history and tradition in the Second Amendment context suggest the exact opposite. And finally, that the court is likely to abandon or significantly reform the text history and tradition test in the coming years, highlighting the inherent instability of the framework. So first point, although text history and tradition methodology appears to be ascendant, it cannot explain key features of the Bruen decision. We're seeing a revolution, I think, in the methodology of constitutional decision-making. For the last 70 years, most of us in this room grew up in the era of interest balancing. No rights were absolute, and the question was whether government had sufficiently good reasons to limit that right, and did so with a sufficiently tailored regulation. But now we seem to be witnessing the rise of a new way of doing things that focuses on text, history, and tradition to determine the constitutionality of various governmental regulations. Nowhere is this more apparent than in the Second Amendment, and Thomas and Bruen explicitly rejects any reliance on interest balancing in favor of history and tradition. But how much did text, history, and tradition really matter to Bruen? On the surface, it appears a lot. If you read the opinion, it looks like there's a lot of text history and tradition there. But when you look a little deeper, there's reason to be skeptical that text history and tradition is doing much of the work. To start with text does not appear to have been particularly influential. The key text was the Second Amendment's phrase of a right to bear arms. And the court said that the right to bear arms was a right to carry in case of confrontation, evoking the idea that the framers wanted to protect against protect against criminals on the public streets. Amicus briefs in Bruin on corpus linguistics databases showed that around 90% of mentions of bear arms in the founding era were about military use. Evidence that I think in any other case, certainly any other less fraught case, would be deemed highly probative, if not conclusive, in determining original public meaning. Thomas's opinion doesn't even address this evidence, insisting that bear arms naturally encompasses public carry in case of confrontation with a criminal. Yet this theme of self-defensive use of firearms on the public streets against criminals is notable mainly for its complete and utter absence in any of the ratification debates and discussions of the Second Amendment at the founding. The court's consideration of history and tradition is also internally inconsistent. The court said that those gun laws, the only gun laws that are constitutionally permissible are those that are consistent with the laws of the 17 and 1800s. But the court makes it a point to hold that shall issue permitting for concealed carry is constitutionally permissible, even though there were no such laws in the 18th and 19th century, and even though shall issue permitting arose decades after virtually every state except Vermont had adopted discretionary permitting. Court also says that guns can be prohibited from sensitive places and cites 3 laws doing that from the 1800s. Not only does the court in other parts of the opinion reject far more numerous examples of severe restrictions on carry, including outright bans, as outliers, but in a remarkable about-face, the court in another part of the opinion says that it doubts that 3 colonial regulations could suffice to show a tradition. My second point is that one prominent way that Bruin purports to use history, by reasoning that a scope of a right is determined by the absence of government regulation, is fundamentally misguided or certainly needs much more specification. Bruin looks to the 18th and 19th centuries and sees a tradition in which there was very little regulation of public carry. And then Bruin draws an inference from this lack of regulation that this reflects a constitutional determination of the scope of the Second Amendment. We saw this too in Mike's discussion yesterday of First Amendment doctrine, that the court finds a tradition of liberty and speech in some of these exceptions, but often from the looking at the absence of laws regulating that particular speech activity. But can we really draw such strong inferences from legislative inaction? There are many reasons why government doesn't regulate something. It could be because it's unconstitutional to regulate it, but could also be because there was a lack of urgency. It wasn't seen to be the kind of problem that it might be now. It could be because there was a lack of institutional capacity at the time to support regulation of the sort that we might see today. It could be that there was ignorance. It could be that there were significant, and indeed there were, political process defects that privileges some voices in the political process while silencing others who might have other views. So inaction may be probative in any particular case, but we need to have standards and criteria for knowing when inaction and a lack of regulation tells us something important, and Bruin does not offer us that. My third point is that text history and tradition is so far proving to be more subjective and more unworkable in the lower courts than interest balancing, opening the door for the very judicial activism that text history and tradition is supposed to guard against. The justification for the turn to text and history is to make judicial decisions less subjective and more predictable without empowering judges to impose their values on society. But the early returns suggest the opposite is true. Courts have reached completely opposite conclusions on a wide range of gun laws, with some courts upholding and other courts rejecting age-based restrictions on firearms, some courts upholding and other courts rejecting restrictions on ghost guns, some courts upholding and other courts rejecting prohibitions on possession of firearms with obliterated serial numbers, We see the same thing with assault weapons and high-capacity magazines, and bans on possession of firearms by people under felony indictments, with some courts saying yes, some courts saying no. The text, history, and tradition test in the lower courts has permitted courts to be highly subjective. Only now the question isn't whether they think government has a strong interest or whether the law is well tailored. Now the question is what counts as a historical analog for gun laws today. And on this, there's very, very little agreement. The courts are also all over the map on how many previous laws it takes to make a tradition. In a case where the government cited 4 state laws, 2 territorial laws, and several municipal ordinances, the court said that wasn't enough, even as other courts have upheld laws with fewer historical analogs. In striking down a state law barring guns in churches and places of worship, one court said that while there were analogous laws in the 1800s, it wasn't clear they were ever enforced, so the law on the books was irrelevant. Compare these results with the interest balancing in the lower courts after Heller, where the outcomes were actually far more consistent and far more predictable. You might not like those outcomes, and perhaps the courts were applying the wrong test in those early cases, but I would suggest that if the court had in Bruin suggested that strict scrutiny was the way to go about doing it, again, a form of interest balancing, we would have much more agreement in the lower courts on the outcomes of these various cases. Finally, I believe that the text, history, and tradition test will be abandoned, or either formally or I think more likely informally by the Supreme Court in the future. Sincere application of this test will lead to the invalidation of a wide variety of widely accepted gun laws, including bans on felons possessing firearms, bans on mentally ill people possessing firearms, and things like red flag laws. None of these laws are deeply rooted in history and tradition. There were no felon in possession bans in the 18th and 19th century, and bans on the basis of mental illness date all the way back to the 1960s. So will the Supreme Court actually strike down those laws? I don't think so. Maybe. But I think that what's more likely to happen, as I think some of our panelists are going to talk about a little bit later, is that the court will likely try to draw analogies at a very high level of generality, focusing on categories like a tradition of banning dangerous people from possessing firearms. But that category is itself made up by the judges. It is a function and a product of the very judicial subjectivity that we're supposed to be trying to avoid with text, history, and tradition. Indeed, there wasn't a tradition of banning quote-unquote dangerous people from having firearms, including specifically felons and the mentally ill who were not prohibited from having firearms, but presumably were equally dangerous back in the 1700s and 1800s. So text, history, and tradition may be becoming the way constitutional law is justified today, but it does not and cannot explain the outcomes that the court has reached and will reach in the future on the Second Amendment. Thank you.
Thanks, Adam. Eugene?
Sure. Thanks very much for having me talk about this. This is a very interesting subject. I've tried to figure out what courts have been doing before and what are doing now, and it's hard to know for sure. There certainly is a lot of uncertainty, although I'm not sure whether it's any more uncertainty than would likely have been present with regard to First Amendment law after the Supreme Court first started really trying to apply the freedom of speech to government action. But there's no doubt that there's a lot of unpredictability in the current rules, and maybe it'll settle down, maybe it won't. But I want to step back a bit, and I want to start out by talking about the history, and then talk a little bit about the doctrine, what I see as the emerging doctrinal structure, and then maybe a little about what might happen in the future, although as Adam, one thing I agree with Adam on is who knows? Who knows what will happen in the future? So here's one way of thinking about this. The Bill of Rights was not intended to lay down any novel principles, but just to embody certain immunities which were inherited from English law and which carried with them well-recognized exceptions. So, for example, the freedom of speech and of the press doesn't protect libels or blasphemy or indecency. The right of the people to keep and bear arms is not infringed by laws prohibiting the carrying of concealed weapons. Provision that no person shall be put twice in jeopardy of life or limb doesn't prevent a second trial if there's a hung jury. This is basically a paraphrase, except for the part about the Second Amendment, which is a literal quote, of Robertson v. Baldwin, the Supreme Court's decision in 1897. The case is, it's not a holding about the Second Amendment as such, because the case itself was about the scope of the 13th Amendment. But sort of the offhanded remark, I think, is noteworthy in part because it was offhand. It's just sort of the understanding, and my sense from reading the cases and the treatises from that era is it was a pretty shared understanding that indeed there were these pre-existing rights that were meant to be preserved, but subject to certain degrees of pre-existing exception. They didn't talk about it as text, history, or tradition, but it seems very consistent with that. Maybe that was wrong in 1897. Maybe even if it was right in 1897, it makes no sense for 2023. But I do think it's part of a long-standing tradition, and it's part of a tradition that actually continues to be quite familiar to us, although there's also a good deal of controversy about it, with regard to some of the other provisions of the Bill of Rights. So, for example, the right to jury trial, right? Let's say, for example, somebody says, you know, we need to have greater criminal punishments for hate crimes. But we think in some parts of the country, juries just are not going to be willing to convict in hate crimes, or for hate crimes. So we think there's a compelling interest in preventing hate crimes and avoiding jury trials, essentially having them be tried as bench trials, is narrowly tailored to that interest, and therefore no jury trial in these cases. That would be pretty clearly unconstitutional. By the way, my sense is, at least there's some reason to think, that on the civil side, one reason why the Civil Rights Act of 1964 did not provide for compensatory or punitive damages was precisely the sense that if it did, then it would have to provide jury trial, which might not have worked in states especially that excluded blacks from juries, and maybe in most places in America, it wouldn't have provided for much enforcement of anti-discrimination law. But again, the reaction wasn't, okay, fine, there's a compelling government interest in preventing job discrimination, so we're just going to waive the jury trial. No, nothing says that either jury trial right is absolute. Obviously, the civil jury trial right requires us to ask if something is an action at law, as opposed to in equity or in admiralty, and the line between law and equity is, especially now that that line has been actually abolished as an institutional matter in most jurisdictions, almost all jurisdictions, becomes even harder to police, but courts try to look at it more or less with an eye towards text, history, and tradition. Likewise, criminal jury trial. Back in the 1930s, I think the court said, well, you know, historically there have been petty offenses with a maximum sentence of 6 months or less that never had to be tried to a jury. I'm not sure if the history is right, but that was the claim. So therefore, the jury trial right does not apply if the maximum penalty is 6 months or less in jail. So it wasn't there's a compelling interest in enforcing these particular offenses. By the way, they're probably the ones that are the least serious. Maybe the interest is least compelling, although maybe there are a lot of them, so that makes it more compelling. Who knows? That wasn't the way that the court articulated it, even if maybe that's the way the justices thought about it. The theory was, you know, text, history, and tradition. We see that more controversially with regard to the confrontation clause, for example. Where the court has tried to refashion the confrontation clause from kind of a freewheeling interest balancing that I believe was adopted like maybe around the 70s or 80s. It was under the tutelage of Justice Scalia, although in this respect it was a right-left coalition on one side and right-left dissent as well. But I believe it was Scalia, Thomas, and Souter, if I recall correctly, Souter, Ginsburg, and Stevens in at least some of those cases that said, yes, indeed, we look at the history of what confrontation meant to the framers and what it has meant since then. Double jeopardy is another such example, that double jeopardy decisions are very much this way. Now, of course, the First Amendment, as we saw yesterday, is very different. And maybe you should treat the Second Amendment more like the First Amendment, where, at least historically, there had been both a lot more kind of policy judgment by the court and subject to strict scrutiny or intermediate scrutiny or some such overlay. But there's certainly, the court does indeed deal with some constitutional claims the way it's trying to with the Second Amendment. And again, note the link between the Fifth and the Second in the Robertson v. Baldwin quote. This has been something that had been kind of this general structure had been raised before. So I think it's done. It's been done for things other than the Second Amendment. I'm inclined to say that it's at least plausible. I'm not sure it's the best solution, but in any event, it's itself part of a historical tradition that goes both from the past and into the present of how to deal with certain kinds of constitutional rights. Now, what one thinks of the particular text and whether the text is being interpreted properly is a different matter. I'm actually inclined to say that because of the history of the Second Amendment being based on the English right to have arms, which was not a right of states. There were no states in England, not a right of the militia. That it makes sense to view it as an individual right. There are lots of other evidence, I think, along those lines. What's more, as the court pointed out in D.C. v. Heller, in 1700s English gun control laws, of which there were some, especially targeting kind of disfavored areas like, Scotland and the like, keeping and bearing was a list of things that was prohibited, but clearly in a civilian context. So, for example, there was a statute in 1748 which talked about the prohibition contained in this act of having, keeping, bearing, or wearing any arms or warlike weapons shall not extend to essentially government officials. So there was a prohibition on keeping and bearing on the part of ordinary citizens, but not officers employed in the execution of justice. So that's a historical argument we could have, but in any case, I'm inclined to think that the historical analysis is likely correct in Bruin, although of course there's a lot of room for disagreement. Now, so let me shift to the second point, which is that it's important to realize that while Bruin rejected this free-form interest balancing, or that one might, that is often labeled intermediate or strict scrutiny. And I do think it's actually freeform. It sounds like it's constrained. I don't think it actually is. I do think it left room for at least two kinds of regulations. And I say left room, and I don't mean necessarily that it validated them, but I think that it did not dispose of them. Besides regulations justified by scope. One is what I call low burden regulations. And that's how I understand the court's validation of the licensing regimes. Adam is quite right that there is no long-standing tradition of licensing regimes for carrying guns. But I think the court's rationale was, look, these regulations are permissible to the extent that they impose only a relatively modest burden on the right. And I think if you had to think through it textually and historically, it ties to the concept of shall not be infringed. That in fact, the infringement is not necessarily any action with regard to a right as an infringement or an abridgment in other provisions. That there is, for example, in some of the concealed carry, the 1800s cases that upheld concealed carry restrictions, there is kind of this strain of, look, you can still have a gun, we're just regulating a particular way of carrying it. We're not prohibiting the carry. Now, it's an interesting question whether today a requirement that you openly carry in a situation where in many places that will get you a lot of unwanted attention, whether it might be a very grave burden. The courts at the time seemed to think it wasn't a grave burden. Rightly or wrongly, there is this tradition of treating lower burden restrictions differently from things that were seen as outright prohibitions or grave burdens. And of course, that's true in a wide range of situations. So for content-neutral speech restrictions, if they leave open ample alternative channels, they're subject to a pretty differential form of intermediate scrutiny. So I think that there is room for that. And it may very well be, for example, my view is that bans on possessing guns with obliterated serial numbers, it doesn't have to be a tradition. It just doesn't abridge the right to keep and bear arms. You could still keep and bear arms. You just can't keep and bear a gun that has a concealed serial number. You can keep and bear arms that have those serial numbers, which are just as effective for self-defense as anything else. Query whether restrictions on so-called assault weapons, restrictions that I do not think are a wise idea, may be constitutional for the same reason. That's actually going to be something the courts will have to decide. One other area is that government acting as proprietor may have different rights than the government acting as sovereign. Again, that's very familiar from First Amendment context, from the Fourth Amendment context. We're seeing a few cases. There are actually a couple of cases, a couple of appellate cases, one federal, one state, involving restrictions on foster parents. That, for example, the one that just came down from Wisconsin involved a rule that says essentially if you have foster children, you have to keep any guns in your home both locked and unloaded, which among other things means that you cannot actually carry them on your person. And the Wisconsin Court of Appeals said we remand for further consideration in light of Bruin, but one of the things that it flagged is you need to talk about the unconstitutional conditions doctrine, right? That maybe one thing that might justify at least some such restrictions is, look, if you want to be a part of this government program, then you have to accept certain kinds of restrictions, but maybe not unlimited restrictions, because after all, among other things, it's not just like while you're on the job. Being a foster parent is a job that also involves you 24/7 being on the job in the home, in your own home. So in any event, I think it's important to realize that whatever role text history and tradition play as to kind of the core of the underlying right to be free from certain prohibitions doesn't resolve the burden question and doesn't resolve, at least in my view, doesn't resolve the burden question. And I think Bruin is consistent with that, and doesn't resolve the government acting in special capacities question. And the last thing I just want to close with is I entirely sympathize with the argument that you need to have some sort of strict scrutiny type escape hatch. But whether it comes to free speech or right to bear arms or as to other rights, like, right, let justice be done, though not if the heavens fall, right? We say, okay, fine, we really believe in rights, but maybe not. Rights are trumps, but not trumps of absolutely everything, maybe. So I think it's a very plausible position, and it may be that the court erred in departing from this. One thing that the court saw though, is that under certain formulations of strict scrutiny, you could make a perfectly plausible argument that a total ban on all guns would be narrowly tailored to compelling government interest, right? There's a compelling government interest in preventing murder, and at least there's plausible arguments. I'm skeptical of them, at least in America, but there are certainly plausible arguments that the only effective way of doing that is of diminishing murders is completely banning all guns. Because so long as there are any guns that are available, they could be used this way. Even if you're not allowed to carry them, well, people will carry them illegally. Even if you ban handguns, people can use rifles. You ban rifles, people can use handguns. Perfectly plausible argument. But you can't have a test, a strict scrutiny test that would allow kind of the core of the right to be eviscerated that way. That's just inconsistent with there being such a right. So I think what the court was seeing is lower courts not doing exactly that, but going pretty far in that direction. And the court's conclusion was that unless, one possible twist, of course, is say, well, the narrow tailoring requirement requires fact-finding about the underlying criminology, but something that I think the court was reluctant to have lower courts routinely do. So I think that's why the court rejected strict scrutiny.
Eugene, I think I'm going to have to exercise the
yes, I am
prerogative
sorry,
here.
and I'm done.
There's a limit to free speech. Thanks. We're gonna move on. It was fascinating. I could listen to you all day, but we just have too many
my
folks on the
apologies,
panel.
Bert. Sorry about that.
Darrell, go ahead.
Great. Thank you, Michael, for this invitation to be on this great panel and a great conference. My remarks are based mostly on a paper that Joseph and I co-wrote called Manufacturing Outliers, which is forthcoming in the Supreme Court review, and gesturing towards a project that I've tentatively called Falsifying Tradition, exploring some of these themes that we've talked about in terms of the new approach in Bruin. So last term, the Supreme Court issued its first major Second Amendment case in about 15 years, New York State Rifle and Pistol Association versus Bruin. The case concerned a challenge to New York City's May issue law, which required applicants to show proper cause or special need to receive a license to carry a gun in public, concealed. Petitioners had characterized the New York's law as an outlier compared to the 43 other states that either have what's known as shall issue permitting or don't require any permitting at all. And at oral argument, Paul Clement, who was representing the petitioners, framed the issue simply as we'd like to have what they're having. In a 6-3 majority, the Supreme Court, in an opinion written by Justice Clarence Thomas, rejected the manner in which lower courts had been analyzing Second Amendment cases. This was a conventional category and protection type of approach where the first question was, are we even dealing with the Second Amendment issue? And the second question was, if we are, then what is the level of protection? This was inspired very much by First Amendment doctrine. And rejected in favor of, as what Adam had identified and Eugene has identified as a text history and tradition only approach. The quote from the opinion is, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct, the government must then justify its regulation by demonstrating that it is consistent with this nation's historical tradition of firearm regulation. Now, during Q&A, I have really a lot of problems with how this is articulated, especially the plain text prong of this new two-part test, but I'll leave that to the Q&A. The court also embraced the petitioner's description of New York's law as a contemporary outlier and went further, casting it and the historical evidence supporting it as outliers as well. The New York litigants are not dummies. They see that there is a change of staffing at the Supreme Court, and they had amassed over 700 years of Anglo-American regulations from the medieval period of the early 20th century to show that New York's law was part of a long-standing tradition, deep and long relating to public carry. And one by one, the majority characterized each of these historical regulations as outliers. Some were too new, some were too old, some were passed by territorial governments, some were passed by Reconstruction governments, some weren't sufficiently enforced, some were enforced without criminal penalties, some were outliers because they were in a population that was too regional or too small. None of the regulations, according to the court, were constitutive of a long-standing historical tradition regulating public carry into which New York's law fit. Now, Bruin's description of New York's law as both a contemporary and a historic outlier raises some fundamental questions about how the justices use that term and what are the jurisprudential conclusions to draw from it. Now, I want to stop here and say that our critique about outliers is focused on the Bruin opinion, but it's not confined to Bruin, but it extends to any kind of methodology that purports to rely on notions of tradition or custom or usage that amasses some sort of body of empirical material, constructs a distribution, and then identifies a practice as somehow outside that distribution. It also assumes that arguments from outliers and tradition are falsifiable and not simple covers for outcomes. As Justice Scalia once said, text and traditions are facts to study, not convictions to demonstrate about. So what is an outlier? Statisticians and empiricists call an outlier an observation that lies at abnormal distance from other values in a population. So to have an outlier, you need to have a set of observations grouped in some way according to some principle and a value or observation that diverges meaningfully from this group. Now, you can't cloak this empirical sounding process as a search for tradition, because tradition itself implies something empirical. To have a tradition or a custom or a practice or a usage, you require some sort of designation of a relevant community, some set of social phenomena or practices or regulations sufficient in number and similarity to form a distribution, and then some duration of time, and practices that deviate meaningfully from this distribution then can be called outliers. Now, Bruin's problem is in using this sort of empirical or empirical light kind of terminology is that it fails in two significant ways: transparency and rigor. Our first objection to Bruin's use of outlier is a lack of transparency. There's a lot of choices that go into the construction of the reference set from which these outliers are going to be measured, and they're not expressed or acknowledged in the opinion. It doesn't explain, much less justify, how the court is constructing this baseline or the conclusions it draw from it. Let me give you some examples. The court relies very heavily on states and thinks that states are the right reference set to construct a distribution. But why is that the case? Permitting in New York is not an outlier compared to some other metric, population, for example, or states with dense urban centers. And note elsewhere, Bruin seems to suggest that population is the right denominator when constructing a reference set. The court is dismissive of regulations in the territories, but if the object of the exercise is to figure out what the original public meaning or understanding or traditions with reference to the Second Amendment were, that's exactly what you'd want to use, the territories, because the territories are the only ones that are subject to the Second Amendment at a time before incorporation. And yet the court sort of casually dismisses these as sort of proto-states, and therefore their regulations are not relevant. Why laws in litigated cases? Why confine yourself to that if what you're trying to do is sort of amass a kind of social history of understandings of people's sort of nomos that they live in, their sort of the legal environment in which they inhabit, then you wouldn't want just laws in litigated cases. You'd want all kinds of data. You would want newspaper accounts. You'd want personal papers and letters. It's not inconceivable that the future, if in fact tradition is the way we're going to do this, might actually look more like corpus linguistics instead of big data approaches to words and their meaning. You just do big data approaches to things like social history. The second problem with Bruin is a lack of rigor. Like, how do you code any specific phenomena? To code something, or to say that you're going to define something as an outlier, it implies something roughly objective, falsifiable, roughly quantitative, based on some sort of method that submits to a disciplinary standard. And this is consistent with the idea that originalism, or traditionalism for that matter, can import a kind of empirical determinacy with history and tradition that other methods of constitutional interpretation like balancing cannot. Now, one thing that I feel pretty confident about, I'm not an empiricist, but I've talked to some empiricists. They say that you are absolutely not allowed to do this. You can't say, what's the distribution I want, and then start coding afterward. You're not allowed to do that in any sort of empirical discipline. And there's all kinds of efforts in processes that are roughly quantitative or empirical to avoid that kind of risk of bias. You might have an empirical process that has blind coding, or use two coders with a tiebreaker, or some kind of coding that's done based on some kind of predetermined criteria. Now, I'm not sure, and I certainly wouldn't say that law has to import all the sort of empirical disciplinary norms of other areas. But if it's going to be factual and falsifiable claims about tradition, it has to submit to some kind of standard. And one of the problems is that this rigor is not present in the Bruin case. Example of this is the Supreme Court cites this case called Commonwealth versus Bliss, which is a Kentucky antebellum case that actually holds something about the Second Amendment right to keep and bear arms, and holds it for a proposition about the original understanding of the Second Amendment, even though by any metric, this case, Bliss, would be an outlier. Why? Because it's essentially holding that the Second Amendment applies to the states in an era before incorporation. So in concluding, we don't come to bury or praise judgments that trim outliers, and I think Joseph and I agree that there are some kinds of justifications for this. The Warren Court's very project of modernizing the law for the 20th century was about trimming outliers. And most recently on the left, the push for marriage equality, as well as other sort of things of the left, have adopted a kind of outlier analysis. Nor do we think that Bruin is the only example of problematic outlier theorizing. Bruin provides a useful illustration because of its salience. It's pretty new. Its insistence on historical objectivity, and its aggressive certitude about what it's doing. But this same lack of transparency and rigor is also on display in other constitutional domains. Our more limited point is to caution that arguments from tradition and arguments from outliers, to the extent that they become relevant to and even determinative of matters of constitutional law, is going to have to mature beyond what Chief Justice Watts described in another context as a, quote, open-ended, rough and tumble way of making a decision, into something far less opaque and far more exacting. Thank you.
Thanks, Darrell. Renee, you up? Good.
Thank you to Michael for inviting me to such a fascinating conference. I'm a legal historian, and in a way, this is an easy job here because there was hardly any regulation of firearms at the time of the founding. We've recently seen several tests for the Second Amendment. Interest balancing with tiers of scrutiny, which the lower courts developed before Bruin, and now, as we've heard, text and history. So these two tests have actually had noticeably different effects in the lower courts, a point I'm going to come back to later. Still, the lower courts have amply demonstrated that any test can be manipulated to achieve desired results. Alexander Hamilton knew that, and that's why he writes in Federalist number 84 that in a republic, the maintenance of a right, whatever fine declarations may be inserted in any constitution respecting it, must depend on public opinion and on the general spirit of the people and of the government. And the government, importantly, includes the federal judiciary. So in the interest of exploring the spirit of the people and of the government, and especially the judges, I'm going to go back to first principles. And we've heard several times that the Bill of Rights often embodied pre-existing rights, and this is certainly true of the Second Amendment. So why do we have a right to keep and bear arms? A long line of thinkers from Grotius, Pufendorf, and Vattel to Locke, Beccaria, and Blackstone have an answer. And the founders of this country very heavily cited, relied on these thinkers. And their answer is personal and collective self-defense. Blackstone was very clear about this. He said, self-defense, therefore, as it is justly called the primary law of nature, so it is not, neither can it be, in fact, taken away by the law of society. And for this reason, Blackstone wrote, the people have arms for their defense. This is a public acknowledgement of the natural right of resistance and self-preservation when the sanctions of society and law are found insufficient to restrain the violence of oppression. So Blackstone and these other foundational thinkers very strongly tie together personal and collective self-defense. The one is the basis for the other. Grotius, Pufendorf, and Vattel rest the law of nations, or what became international law, on a close analogy to personal self-defense. Personal self-defense is not only the basis of relations between nations, but also of resistance to tyranny within a state. But courts deciding cases often have not focused on these first principles. And in particular, under the interest-balancing tiers of scrutiny tests that applied before Bruin, courts nearly always upheld restrictions on the right to keep and bear arms, including almost total bans on carry outside the home and AR-15 style rifles. Under Bruin, with the text and history standard, more courts are willing to avoid restrictions. There is a definite difference there. Even so, the results under the text and history standard, as we've heard, are highly variable, just as Alexander Hamilton would have predicted. And the best example of this comes from Illinois. Illinois, we have almost a perfect test case. In 2022, this is a few months after Bruin was announced, Illinois passed a statute called the Protect Illinois Communities Act. The legislature did this in the wake of a shooting in Highland Park on the 4th of July. Among other prohibitions, the act bans the AR-15 rifle and AR-15 style rifles and magazines of over 10 rounds for rifles. The Illinois Act was immediately challenged as unconstitutional under the Second Amendment in multiple lawsuits. So some were brought in the Northern District of Illinois and some in the Southern. The plaintiffs all applied for preliminary injunctions of the act. On February 17th, 2023, the Northern District of Illinois issued an opinion on the question. And on April 28th, the Southern District issued an opinion. The cases involved, therefore, exactly the same statute in the same procedural posture. The cases came out the opposite way, diametrically opposed. So what happened? How did they arrive at such different results? The Northern District of Illinois denied the injunction, claiming that plaintiffs were not likely to succeed in overturning the statute. And in doing so, the court engaged in, let's say, a creative interpretation of Bruin. So Bruin, as we've heard, requires the courts first to ask whether the Second Amendment's plain text covers an individual's conduct. That is, whether the person seeks to keep and bear arms. And if so, the Constitution presumptively protects that conduct. And again, as we've heard, in order to uphold a regulation, the government must demonstrate that it is consistent with the nation's historical tradition of firearms regulation. And Bruin explains that the historical tradition supports prohibiting the carrying of dangerous and unusual weapons. But, Bruin says, the Second Amendment protects the possession and use of weapons that are in common use at the time. So the Northern District managed to sidestep many of these issues. The court refused even to hold that the banned items, AR-15 and these magazines, are arms within the meaning of the Second Amendment. But sensing that that was a bridge too far, the court went on to address the historical tradition. And on that point, the court ignored the question of whether AR-15s and magazines of over 10 rounds are in common use. And that was convenient for it because there are more than 24 million AR-15 style rifles in the US, and the standard magazine for them holds over 30 rounds. So 24 million dwarfs the 200,000 stun guns that the US Supreme Court found were sufficient to meet the common use test in Caetano versus Massachusetts in 2016. AR-15 style rifles are among the most popular arms produced in the US today. The Northern District proclaimed that the AR-15 is dangerous. And the Supreme Court said dangerous and unusual, but the Northern District decided to ignore the unusual part. The Northern District then launched into a litany of regulations of dangerous weapons, such as Bowie knives from the early 19th century, clubs from the 17th century through the 19th, trap guns, silencers from the 20th century, and concealed weapons from the late 19th to the early 20th century. And it argued that the AR-15 is analogous to those. Therefore, the AR-15 and its standard magazine can be banned completely. I have to say, the weakness of these analogies is striking. So we have knives, clubs, trap guns, and concealed weapons. Nowhere did the court claim that, in the nation's historical tradition, a common form of rifle was banned. And these include repeating rifles, which were in common use in the late 19th century. So we have here a question of the level of generality. There's also a question of the timing of these regulations. You'll notice that many of them come far after the founding, and almost all, as almost all regulation of firearms did, and I hope we can discuss this question a bit later. So that was the Northern District. In contrast, the Southern District of Illinois said that the AR-15 and magazines of over 10 rounds are arms within the meaning of the Second Amendment and are in common use. And therefore, the Southern District granted a preliminary injunction against the statute. The Seventh Circuit immediately granted Illinois' motion for a stay against the injunction in a one-sentence order without giving the plaintiff an opportunity to respond. But meanwhile, in the Northern District case on May 1st, Justice Amy Barrett directed the state of Illinois and the city of Naperville to respond in an emergency application for an injunction pending appellate review. It's going to be interesting to see how this plays out. The state of Illinois, the Northern District of Illinois, and the Seventh Circuit have all manifested a desire to sidestep Bruin. And this is the sort of state and federal judicial conduct that led to the text and history test in Bruin in the first place. This sort of creative interpretation illustrates why the courts need to focus on the first principle of self-defense. The AR-15, in fact, does facilitate armed self-defense. And contrary to what you may hear, it isn't highly useful for that purpose. Because of the size of the AR-15, it's especially useful in repelling home invasions. The AR-15 has more stopping power than handguns, less over-penetration, and is much easier to control and shoot. It has very little recoil. I'm happy to get into technical details if anyone wants. But we at this conference, and virtually all judges, live lives that lead us to downplay the importance of personal self-defense, the right that was so foundational to the founders. And therefore, many of us tend to downplay the right to keep and bear arms. Most of us do not have to worry about our safety when we take a walk in our neighborhoods or travel to work or go to the grocery store. But that is not true of everyone in the United States. The South Side of Chicago provides a stark example, and some folks in this room are very familiar with that. My two oldest children are undergraduates at the University of Chicago on the South Side, as you know. And it happens that my two children's dorms are next to each other on 61st Street. That is not far from O Block. You may not have heard of O Block, but if you ask someone who is a teenager or in their early 20s, they may well have heard of O Block. That is the name given to the 6400 block of South Martin Luther King Jr. Drive at the intersection of 64th Street. That block is dubbed the most dangerous place in Chicago. Shootings are common there, and my children routinely hear gunshots from their dorm rooms. On May 3rd, 2 weeks ago, 4 people were shot just around the corner from O Block. Gang members named the block after O.D. Perry, a 20-year-old gunned down there in 2011. And O Block has spawned an entire genre of music called drill music. And this is what those younger folks may have heard of. And the folks participating in this are usually called rappers and include Chief Keef and King Von, both from 64th Street. My son calls Chief Keef the Mozart of our time. Chief Keef raps about the bloodbaths on O Block, as does King Von. He named his debut album Welcome to O Block. And my children report that these rappers are so famous that their friends and acquaintances in France and Germany know about O Block. So in the interests of thorough research, I listened to Chief Keef's Love Sosa and King Von's Crazy Story. I'm afraid I could only understand about 10% of the lyrics. And what I did understand, I cannot repeat here. But I did understand the drugs and simulated killings in the videos. Shortly before I visited my children in November, a student was shot at 10:30 at night just south of their dorms. And I asked them, "Are you worried about that?" I was amazed. They were as cool as cucumbers. They said, "No, not at all. Everyone knows you don't go south of 61st Street at night." And as I spent some time on campus, I started to understand why. 61st Street is the limit of the jurisdiction of the University of Chicago Police Department. That is one of the largest private police forces in the United States, authorized by the Illinois Private College Campus Police Act. They are very efficient. They will appear almost instantly when a crime is reported. They rigorously investigate violent crimes and often actually identify perpetrators. The people who live on 64th Street are not so lucky. They are under the protection of the Chicago Police Department. And like so many big city police departments following the George Floyd riots in 2020, they face a retention and recruiting crisis. They police much less proactively. And they're mainly reactive, and their reaction time is slow. So in Chicago, depending on the neighborhood, after a priority 911 call, the police will arrive somewhere between 6 and 8 minutes later. But that's average response time, but the response time can be much longer. It can be, in the case of one call in 2022, which was a shots fired call, 178 minutes, just 2 minutes short of 3 hours. So bottom line is that my children and the University of Chicago in general are fairly well protected, but not true of the rest of the South Side. So most of us and most judges live in places that are at least as safe as the University of Chicago. And we don't think much about the use of firearms for self-defense. But if you live on 64th Street and don't have a firearm, you are utterly at the mercy of thugs. So we can have all the historical tests we want, and courts will produce bizarre and strained analogies to the regulations of the past. But it's important to keep in mind on these first principles of self-defense. We can call this a telos-driven interpretation, if you want. As Vattel put it, where the public authority cannot lend us its assistance, we resume our original and natural right of self-defense. And that right is embodied in the Second Amendment. Thank you.
Thank you. Okay, Joseph, you're batting cleanup.
All right. Thank you, Bert, for moderating. Thank you, Michael, for pulling us together. Thank you all for being here. I want to start by repurposing a line that Genevieve used yesterday, bemoaning the fact that First Amendment scholarship sometimes gets ghettoized, I think was her phrase. From a Second Amendment perspective, I think our neighborhood is regarded by many as even less desirable and perhaps scary. But I will say, based on just the presentations now, hopefully we are demonstrating how important and interesting it is, thanks in part to Bruin. I'm going to keep my remarks really brief, conscious of time, and also because I don't want to repeat things that have already been said, much of which I agree with. I've been sort of rewriting my talk on the fly here. As I see it, the biggest threats posed by Bruin, many of which we're seeing manifest in the lower courts already, are of obfuscation and judicial discretion and of a lack of transparency and a threat of anachronism. Just to put, again, sort of on table how challenging it is, I think, for judges, or scholars for that matter, to reason based solely on historical tradition, as Bruin purports to say, to evaluate the constitutionality of things like prohibition of guns on subways, or in airplane cabins, or on BART, or in summer camps, or zoos, or in daycares, or in domestic violence shelters, or of weapons that the framers couldn't possibly have imagined, or of people like survivors of domestic violence who the founding generation underprotected. I think what we've seen, as Adam described, is a lot of chaos in the lower courts, a lot of results pointing in opposite directions. I would add to that that there's a simple sort of practical problem that lower courts are struggling with, which is whether and how to, for example, rely on historians as experts in these Second Amendment cases just to testify, enter expert reports about what the historical record was. Many historians are balking at that role to say we can't possibly do that responsibly on a briefing schedule, but just implementing Bruin at that very practical level I think has led to a mess. So I incorporate a lot of what has been said, incorporate by reference a lot of what has been said about what's troubling of Bruin and its aftermath. But since I'm going last, I will maybe take a different tack and try to present a reading of Bruin that doesn't fall prey to that kind of anachronism, because while I agree with Adam that the courts, I think, are going to slowly back away from the intense readings of Bruin we've seen in some lower court decisions, I don't think Bruin's going to be overturned anytime soon. I don't think that the court, even if it does take one of the many Second Amendment cases currently pending, is going to significantly revise Bruin. I think what the best we can hope for is some recuperation rather than a repudiation. And so drawing on two forthcoming papers, one called Originalism by Analogy, co-authored with Eric Rubin, and another called Guided by History, co-authored with Reva Siegel, I'll try to offer at least some way to avoid this problem of anachronism through analogical reasoning. The basic takeaway, and again, taking from the paper that Reva and I have written, I think Bruin, properly read, treats history as a guide rather than a hard limit on what kinds of gun laws are permissible today. And this is actually drawing on the way that the text, history, and tradition test evolved. If you trace it all the way back to then Judge Kavanaugh's dissent in the Heller II case in the D.C. Circuit, he recognized text, history, and tradition will not speak directly to modern gun laws, and that when those sources run out, the result should not be to read a silence as evidence of lack of power to regulate, which I think is one of Bruin's most glaring flaws, but rather to reason by analogy from the historical sources that exist. So I just want to emphasize this analogical reasoning is, I think, the heart of Bruin's test. The court uses the phrase analogy 30 times in its opinion. That is the core, I think, of the test that it prescribes. And of course, the core of analogical reasoning is comparing two or more things by reference to some principle of relevant similarity. Now, there's a rich literature on analogical reasoning in law. I'm not going to try to cover it here. My reading of that literature is that it has not intersected much with the literature on originalism. And that's too bad, because I think actually these are some common problems. Most of the analogical reasoning literature is about comparing cases or fact patterns, not new and old laws or facts. And I think Bruin makes that incredibly important to think through, because under Bruin, the court is not using original public meaning to identify the core of the right to keep and bear arms and then implementing it or constructing it through heightened scrutiny or something. It is prescribing historical analogy as the test. And that feels to me unique. Now, of course, it needs a principle of relevant similarity to do so. The court identifies two, or highlights two, what it calls metrics, which are why and how a historical and modern gun law burden the right to self-defense. Now, why and how sound to me like synonyms for end and means, but the court is very clear to say we are not doing means and scrutiny here. This is about analogy. It's not about sort of smuggling in some kind of interest balancing. The court does say, and this is important, that the historical and modern laws don't have to be twins. Here, quoting from the opinion, so even if a modern-day regulation is not a dead ringer for historical precursors, it may be analogous enough to pass constitutional muster. So as Reva and Eric and I emphasize in our papers, that kind of analogical reasoning licenses a form of change. It says, for example, and the court actually points to this, that there are various sensitive places that might be subject to gun prohibitions today, even if they weren't in 1791. You have to compare the why and the how. I'm happy to talk about this more in the Q&A, but I think it echoes something Michael was saying yesterday about First Amendment categories and historical purpose underlying their exclusion. Now, to be clear, and this is maybe picking up some things that Renee just said, I think this is a principle that runs in both directions, right? It means allowing new forms of guns, not just black powder muskets. But if that's true, then it also has to allow various forms of new gun regulation, protecting new forms of political community and against new forms of weapons threats. I think a big mistake, and Bruin falls prey to this, is to define the right very broadly and then to demand from the historical record closer to one-to-one comparators. That asymmetry, I think, explains some of the worst lower court opinions, and Adam highlighted a few. One that I just want to call out by name is the Fifth Circuit's decision in Rahimi, which some of you may be familiar with. This is the one in which the court struck down 922G8, which is the federal law prohibiting gun possession by people subject to a domestic violence restraining order. And the Fifth Circuit panel recognized that there is a historical tradition of prohibiting guns by those thought to be dangerous. Now, in the founding era, that often meant black Americans, Native Americans, those thought to be disloyal. But the court said that's not analogous, and here I'm quoting, because the purpose of those laws was the preservation of political and social order, not the protection of an identified person from the threat of domestic gun abuse posed by another individual. I think this is a terrible reading of history, and it's terrible analogical reasoning. In fact, if anything, it's just wrong as a matter of history, because as Laura Edwards and others have shown, in the founding era, domestic violence was treated more as a threat to the public order than it was a private wrong. That's the basis of, for example, the system of peace warrants. But it's also, holding aside the historical error, it's just anachronistic in a way that shows how much judicial discretion is at work here. The whole point of 922G8 was to break with that tradition and to guarantee a political and social order in which women as well as men are entitled to equal protection of the civil and criminal law. And I have to credit Riva for this line. It came out as we were writing our article. Rahimi was issued on Groundhog Day, and it treats the Constitution as a script for Groundhog Day. It literally demands that we do only that which our predecessors have done. That strikes me as bad originalism, and as I say, I don't think it's compelled by Bruin. So what remains, I think, to recuperate Bruin is to put some more meat on the bones of this analogical reasoning test. Mindful of time, I'll just close here, but as I see it, there are at least three main tasks there. One is to better identify principles of relevant similarity in order to make the comparisons possible. Second, I think, and you've heard this already a little bit, is to pay attention to levels of generality. This is obviously a common question in legal reasoning and originalism reasoning in particular, but to pitch questions too narrowly, I think, is to read too much into historical silences. And then the third thing, I think, is that courts have to be attentive to the institutional limitations of doing the kind of historical work that at least some of them think that they have to do, right? Those of us who've done historical work on gun regulations know it is time-consuming and hard, and one can miss, just for lack of time, what might be potentially probative. I do think, too, that even under this analogical test, in order to compare historical and modern laws, it remains important to know how the modern law works, the how and the why. And here, I think that Renee's argument for coverage of assault weapons under the Second Amendment is the right form of argument, as I understand it, which is to focus on what we care about, which is the burden, for example, on self-defense and the protection of public safety and the public sphere on the other side. That is exactly the kind of discussion we should be having, whether we agree or not, rather than trying to draw some kind of strained analogies to historical laws that simply don't speak to modern problems. So my hope is that despite Bruin's shortcomings, the lower courts will be able to recuperate this and come up with workable doctrine as they did in the aftermath of Heller. Thank you.
Thank you. I'll just make one point on Bruin and then turn it back to the panel. It may surprise many of you, knowing my politics and much of my litigation history. I think Bruin is rightly decided. It's rightly decided, but not because of the text and history approach. It's rightly decided because once you recognize an important constitutional right, you simply don't license local administrative officials to have complete discretion about who exercises it and who doesn't. And so for me, Bruin was simply a replay of the late 1930s licensing cases dealing with picketing and demonstrating, in which the court began the modern First Amendment tradition by striking down laws that essentially delegated to local law enforcement officials complete discretion about who could exercise First Amendment rights. And I think Bruin was guilty of the same complete grant of standardless discretion to local officials. And so that the case, I think, could have been decided in the very tradition that instead of opening up the can of worms that we've heard today. And I'll just share with you, when as many of you know, I was one of the founders of the Brennan Center years ago. And one of my tasks was to go ask Justice Brennan if he would agree and allow the institution to be named for him. So I went down to Washington. He was in retirement, and spoke to him in his chambers in the Supreme Court. And we got into a conversation about history. And I asked him how he used history, and he said, well, I do use history. What I do is I imagine a reasonable founder, and I sit the reasonable founder next to me, and I ask the reasonable founder what the reasonable founder thinks the purpose of the textual provision is, and how that reasonable founder would construe the text today. And he said, and that's what I do. It's a kind of constructive originalism. And I smiled and I said, Justice Brennan, how many times does the reasonable founder disagree with you? And he allowed that he couldn't recall any significant disagreements. And so I'm thinking now, maybe the same story should be told of how many times will an Article III judge find a historical fact that will force that Article III judge to decide the case in a way that is inconsistent with his deep political beliefs. And I think about as many times as the fictive founder disagreed with Justice Brennan. Have we really made any progress toward an objective jurisprudence by simply transferring the Brennan description, which was clearly not objective, to this new description, which is clearly not objective? And if we can find some way of getting toward objectivity to eliminate insight, Michael's point yesterday, I would love to hear it. So let me give the panelists a quick chance to disagree with each other and to say something if they wish, and then I'd like to turn it over to the audience. So panelists, here's your chance. Okay. Rebecca, you want to ask folks in the audience if they have anything to say?
First of all, I'm not a lawyer, so if my question sounds weird, it's because I'm not, and thank you so much for a very distinguished panel. So my question as a non-lawyer, somebody who is interested, I'm from Europe originally, and I was born in Franco, Spain, so for me, individual freedoms, I mean, this is the best country in the world, because if this country falls, I don't know what else will go. So my question is, the way I see the Second Amendment is the way it is today as the cost of freedom. We allow a lot of, the view of the First Amendment is very expansive, and the cost is suing somebody for defamation in the US is almost impossible. And we accept that risk. Reputations have been ruined, a lot of people have lost their jobs, and we don't see a problem with that. And yes, I'm not defending mass shootings, to be clear. But I think that the cost of having a free society, that we are not Russia, Europe has a history of totalitarian regimes, and we may be on the cusp of the emergence of another one in Russia. So the cost of freedom is the free Second Amendment regime that we have. So that's my question.
Thank you. So, anybody want to comment on that? But, okay, let's move to the next question.
No, I was going
Oh,
to
go ahead.
So just really quickly, I think that I understand the point and the observation, but as Joseph and I wrote, I think there's a fallacy at the heart of it, and the problem is that it's the kind of Manichaean idea that you either have no regulation and you have freedom, or you have regulation and then you're in Franco Spain, or you're in Nazi Germany. There's a lot of space in between those two things, and that's where the important questions need to be asked and answered.
Just to be clear, Bruin does not take that view. Right?
Absolutely.
Bruin
does not
certainly recognizes that there is room for regulation. The question is how much?
Yeah.
And in particular, could there be regulation that basically completely prohibits people from being able to carry guns?
Yeah, that's right.
And if I can just add a 30-second observation, I think that additionally, I think it's important to recognize the constitutional rights, interests, and freedoms on both sides of this equation. I mean, there is the freedom of others to attend church or worship or vote or speak without fear and terror, which is part of what the rights are trying to pick up. Just before this panel started, I overheard some people talking about school shootings, and one thing I just want to emphasize there is when we consider the costs of those, it's not just the horrific number of children who've died in mass shootings, which is in the hundreds since Columbine, but the hundreds of thousands who've been traumatized by being in a school where that happens, and one I think should also think about their freedom, interest, liberty as well.
Thank you. Elon Werman from Arizona State University. I want to move away from what the Supreme Court's actually doing in these cases, which I always find somehow less interesting. And I'm listening to Renee and Joseph, and I'm wondering if anyone's done any work on the protection of the laws and as it relates to potentially the right of self-preservation or the Second Amendment rights. I don't want to preview too much the 14th Amendment panel, which I'm going to be on, but moving away from incorporation, due process, and so on, is there an argument that a lot of these cases could be resolved under the original meaning of protection of the law, which at a minimum includes judicial remedies, so it's against, it's a protection against private interference, private invasion with private rights, And so that at minimum includes judicial remedies and the protection of public authorities against private violence, against Ku Klux Klan violence, right, for example. And so it seems to me that maybe protection of law would solve Renee's problem of unequal police protection in various areas in Illinois, and if there's unequal protection, the law must provide a means for self-protection, for example, but it would also solve the domestic violence problem where women or anybody in a domestic violence situation is entitled to protection from private violence, and maybe that would justify disabling it. And so I'm just thinking, if there's a way to make both Renee and Joseph happy, like that's something worth exploring. So has anyone written about this in the gun literature, or do I have to write a paper, or where do we go from there?
I think you have to join our neighborhood, Elon.
Yeah.
We always welcome more. I actually think I'll defer to Daryl on this. I think this is related to your projects on outlawry.
Yeah. So, I mean, it's a really interesting point. So, and it raises a lot of interesting questions. So, in response to your last question, I don't know if in the gun literature there's law literature, but there's an interesting book by this guy named Jonathan Obert who wrote The Six-Shooter Nation, which is about the sort of rise of policing. So the phenomena that you arrived at, whatever would, I guess there's a lot of things to point out. One is, the idea of a professionalized police force is a fairly newish concept, right? Middle 19th century, right? We have Reconstruction. At the same time, you have an idea that we're not going to have community policing with private arms, called by a magistrate or, the local sheriff, that we're going to actually have a professionalized body to do so. The equal protection issue is interesting, but then you have to then totally reimagine what state action looks like, right? So what happens when you have a bunch of, self-appointed citizen protectors that say, who is that person running in my neighborhood? I'm going to go investigate, right? And that person says, who are these people that are rolling up on me with guns? And that person reaches out to try to push the shotgun away and gets shot. That's Ahmaud Arbery. You have to have a completely different theory of what state action is in that dynamic if you end up saying, because the police are not capable or inadequate, we're going to have community policing, because then how are you going to have any kind of controls on that kind of behavior?
Well, in effect, you have to have community policing in a lot of places, right? And about the point of the equal protection and so forth, of course, the famous nickname for the Colt 45 was the equalizer. And so it is in and of itself an equalizer. I would say, though, that there are places, I'm not entirely opposed to gun regulation, there are places where your safety can be pretty much guaranteed. Courthouses, for example. So I'm not opposed to bans on guns in courthouses. People going into courthouses are all very thoroughly screened, and in addition to that, there are armed bailiffs everywhere. So I think under those circumstances, you don't have to worry about armed self-defense. So I think this principle of looking to the purpose, self-defense, and then seeing where it applies and where it doesn't is very powerful and not related to text and history necessarily.
I do want to disagree with Renee on one point, which is a common error in the architecture and the lingo of gun rights, which is to collapse self-defense and the thing used for self-defense into the same thing. And it's really easy to imagine, scenarios where you have persons that have natural moral rights to self-defense, but no equivalent right to keep and bear arms. A person in a prison is probably more at risk than anybody in this room or anybody outside a prison, and yet we would never think that a person in a prison, who's been incarcerated there has a right to keep and bear arms, in their cell because of the present risk. So they're not the same thing, and I think it's an error to keep thinking about the thing used for self-defense and self-defense itself as being coterminous.
I'm merely an undergraduate, so forgive me if I dramatically misstate the intellectual history here, but I found it a really interesting idea to think about what the first principle of the Second Amendment was, but I was a little worried about it being a natural right to self-defense. And I mean, certainly it would be if Grotius is the important commentator here, but I think there must be at least another very old tradition, I mean, at least as far back as the founding of Rome, that has profound influence on the American founding, and this would be the Republicans. So it's my understanding that republicanism, a key feature of active citizenship and maintenance of a republic, is bearing arms not for any individual benefit, but for the public good. And it may be, and this certainly shows up in the Anglican context. I mean, James Harrington wasn't John Locke, but he was certainly no small figure, especially for the founders. I was wondering if perhaps something like Machiavelli's discourses might have more relevance than, say, the titans of natural law in early modern Europe.
Anybody want to comment on that?
Well, if I could just say, the English Bill of Rights, which seems pretty likely the Second Amendment was modeled on, secures to subjects, Protestants only, thankfully we went beyond that, and various other things. Pardon? So secures the right to have arms. So that's, you come to America, you remove the suitable to their condition, it's sort of a class-based restriction. You remove, doesn't mention the as provided by law, but basically this is a tradition of not a right of the militia, it's not a right of some entity, it's a right of subjects, a right of citizens. Now, one of the purposes, as I think Renee pointed out, is it is a purpose to kind of deter government tyranny, if necessary, fight against government tyranny. But another purpose was to protect themselves against private tyranny, private oppression. So I think that the framers would not have thought that those things are inconsistent with each other. They don't say follow Machiavelli rather than Locke. I think that they would say that we inherited from the English a right to have arms. Each of us has this right, and it has these multiple functions.
I'm always amused when we get to this point in a debate that we have just eliminated the first half of the Second Amendment. I mean, the preamble doesn't talk about private. The preamble talks about well-regulated militias. And Heller made that disappear by a sleight of hand and took the relevant text off the table. And now we're free to range way far from the relevant text to start talking about private rights. So I wonder if you put the preamble back on the table, whether Machiavelli doesn't come onto the equation much more effectively. But go ahead. You have
Sorry, he does in fact. Machiavelli has a terrific passage in The Prince where he says, he advises the prince, do not under any circumstances invade Switzerland. And the reason he says that, he says, because the Swiss are all armed to the teeth, and they will resist and they will defeat you. So there you go. Again, this very close intertwinement of the personal right with the collective.
If I can add just 10 seconds on this, I do think that we should also recognize the ways in which guns, although they can be used to overthrow or resist a tyrannical government, can also be used in a sort of false positive, seeing tyranny where it doesn't exist, way of undermining and threatening democracy. Reva and I write in a prior paper about the storming of the Michigan legislature, you all may remember 2 years ago, by an armed mob, which forced the legislature to end early. All people advocating that we are resisting tyranny, 0 of whom were arrested. And so again, when we think about sort of harms that guns can impose, it's not just the astonishing body count, but I think also potentially undermining the public sphere in which a democracy depends.
You've been patient. You got the last word.
Okay, well, thank you very much. My name's Dave Paul, private citizen, and I'm very glad to be here. I don't think I need to look to Machiavelli or anybody like that. We can look even closer for someone to offer relevance on this. Dr. Sowell offers the observation. There's no solutions, there's only alternative courses of action. And some have consequences we like, some have consequences we don't like. Now, we live in a society, I was asked to take a pledge to uphold and defend the Constitution of the United States. I was almost crying when I did that because it meant something to me. But that means that the man makes the pledge. The pledge doesn't make the man. So we're not going to find a perfect solution to this, but we do need to recognize that having the right to defend yourself offers the opportunity to go about one's business that you would lose if you lost that right to defend yourself. Now, I'd like to add something to that. I went to an event one time, and somebody thought to ask me the question if I brought a weapon with me. And when I told him no, he goes to his car, gets out a 9mm, and asks me why he shouldn't shoot out the tire to my car. And I just basically told him, because you would have proven that Locke was wrong and Hobbes was right. Have a nice day.
Thank you. Well, I'm going to declare this panel miraculously at an end, miraculously on time. So thank you very much for an extraordinary time.